afternoon, and thank you for joining us. So we're going to spend today talking a bit about E-2 visa options, where there's a low investment amount or other factors that make it a riskier case. So a few things before we get started. Some of you may know that Scott Legal was founded on an E-2 visa over 10 years ago. Our founder, Ian Scott, is in the US personally on an E-2 visa and has, vast experience with that. Scott Legal is also a full service immigration firm, but we focus primarily on E-2 visas. We processed hundreds of them, and we typically process E-2 visas that are higher risk, meaning lower investment amounts. We've processed at consulates around the world, but our primary two consulates are Toronto and London. We will continue our webinar series doing at least 2 webinars a month on various immigration topics. So let's turn to our panelists. We're very lucky today to have Jie Wang, who's a senior associate at Scott Legal and has extensive experience with E-2 visas. My name is Kelly LeGrand-Wiener, and I'm the managing attorney at the firm, and I'll also be speaking later in the presentation. If you have questions throughout the presentation, please send them in the chat box. We may answer them if they're relevant to the part of the presentation we're in, or we may save them for the end. So either way, that's how to send your questions. And finally, this webinar is being recorded and will be made available on demand. So without delay, I'm going to turn it over to Jie to get us started with the presentation.
Thank you so much, Kelly, and thank you everybody for joining us in today's presentation. So let's get started and talk a little bit about the E-2 visa requirements. So what is an E-2 visa and what are the key requirements? So the E-2 visa is a non-immigrant visa or investors who are seeking to come to the US to develop and direct a US enterprise that they invested in. So the E-2 visa won't necessarily directly lead to a green card, but the investor can continue to extend the visa indefinitely as long as the applicant continues to meet the E-2 requirements. Now, to qualify for the E-2 visa, the applicant can either purchase an existing business or start up a new enterprise in the United States. So with regards to the requirements, the applicant must be a treaty country national. And by that, we mean that the applicant must be a national, so have a passport in a treaty, in a country that has a treaty, applicable treaty with the United States. And you can find a list of what are the treaty countries by Googling this. And we also have resources on our blog and website. Now, the applicant should also own at least 50% of the enterprise that they are setting up or purchasing in the United States. And with regards to the investment itself, so the investment of the money into the business must be putting the funds at risk, which means money should be actually spent. And the amount of this investment must be substantial. Now, there is no hard minimum that is regulatory required for the minimum investment amount, but the investment must be substantial in light of the needs of the business. So what this means is all expenditures that is needed to start up the business must have been made. Now, there is also a requirement that the source of funds must be from a legitimate source. So for an E-2 visa application, each applicant would need to prove that the funds used to start up the business have been sourced from legitimate sources, such as saved earnings, employment income, a gift, or a loan. Now, one requirement is that if the source of funds being used is a loan, the loan must not be secured by the assets of the E-2 business or the E-2 business itself. So, for example, you can procure a loan that is an unsecured loan. It could also be a private loan from a relative or a friend, or you could get a loan that is secured on your other property, other personal property that is unrelated to your E-2 business. Now, let's talk a little bit about marginality. By marginality, we mean the revenue generation potential of the business. So the E2 business cannot be just a one-person shop, so to speak. So the profitability of the business must be enough such that the profits flowing in from the business, the revenues must be enough, not only just to support the investor and his or her family, but also to hire additional U.S. workers and to support U.S. jobs. So we do recommend that the business have enough profit generation potential to employ 3 to 4 employees by within the next 5 years of the business's operations. Now let's talk about the real and operating requirement with regards to the E2 qualifications. So either the E2 business must already be taking revenue, or the E2 business must just be ready to start running on the ground once the visa is granted. So this means the business entity must already be established, the business corporation or an LLC, for example. The business space must already have been secured, so the lease agreement must already have been made. So the office must be set up. Required licenses must have been procured if the business is operating in an industry that requires such a license. And we do recommend, and it is recommended and could be a strengthening factor if you have client contracts for services already in place, so that you can show that the business is ready to go up and running on the ground. So another requirement is that the applicant must be coming to the US solely to develop and direct the business. Now, this means the applicant would really be coming to the US to manage the E2 business, not to come to the US to work as an employee or a worker, which means you would really be playing a managerial role, not necessarily providing on-the-ground services. So you would be expected to hire employees to do the work for you. The last final requirement that I would like to talk about is non-immigrant intent. So the E2 visa is technically a non-immigrant visa, so you do need to show an intent to return to your home country upon the expiration of the E2 visa. So, and this is usually quite a simple process. It is usually satisfied by a signed declaration, a signed statement by the applicant showing that they do have such non-immigrant intent. All right, so now let's go on to the next slide. We can talk about the other aspects of the E2 requirements. So who can apply for an E2 visa, and how long does an E2 visa last for? So you need to be a national of a treaty country, right? And as I mentioned before, you can search on Google treaty countries, Department of States, and you will see a list of the countries that have signed the applicable treaty with the United States that makes you eligible for this visa. And this really includes many countries in Europe, Africa, Asia, Latin America, and the Middle East, including the UK, for example, Mexico, Canada, Chile. And this list is updated from time to time. And Israel, for example, was added relatively recently for the E2 category. As of note, China and India do not participate in the E2 treaty. So nationals of China and India cannot qualify for the E2 visa. And here it is worth mentioning again, as I noted before, that national of the treaty country means having a passport in that treaty country. So this does not depend on the country of birth. So for example, a dual national of India and Canada, for example, could qualify for the E2 visa based on their Canadian passport. Okay. And how long would an E2 visa last for? So the duration of the visa itself would depend on the applicant's country of nationality. And this is also, you can look it up by Googling reciprocity schedule, Department of State. You can look under each country category. And for many countries, the visa itself is valid for 5 years. But for some countries, the visa validity period can be as short as 3 months. So it is worth looking at what the reciprocity schedule is for your particular country. Now, it is important to note here that the length of the E2 visa is different from the length of the E2 status, which is 2 years for each entry. So the visa validity period is the length of time during which you are able to travel to the US with that visa, right? Now, this is different from the E-2 status, though, which is granted at the time of entry. So this means how long are you allowed to stay in the United States once you come into the US under your E-2 visa. So once you're admitted at the border, it is for 2 years. You can stay in the United States and develop and direct the business. So for example, even if you have a visa that is only valid for 3 months and you apply for admission at the border during the validity period of 3 months, you can still stay for a longer period after you are admitted as an E-2 investor. All right. So now let's turn to the next topic, which would be how much investment then is needed for an E-2 visa. So as I noted before, there is no hard minimum in the regulation or law on how much investment is considered substantial to qualify for the E-2 visa. And an important thing to note here too is that what amount will be considered substantial will depend on the type of business that is being started. So for example, for an office type consulting business, service-oriented businesses, for example, an accounting firm or law firm, for example, this would likely require a lower amount, let's say around $50,000 to set up that business, because that may not be that many operating upfront costs to set up the business. You can get the office, you can get a computer and certain office equipment, but that could be enough. So you could get a lease, you could get the furniture for the office, you could get the computer equipment, but $50,000 could get you in a good place to set up and run the business. By contrast, let's say that you are developing a manufacturing company or a retail-based company or something that requires to have a factory. That kind of business would certainly require a higher amount because typically you would need more expensive equipment to set up and run the business. Machinery, for example, a larger space to warehouse the inventory, for example. So what would be considered a substantial investment would naturally be higher than what is required or expected in the consulting firm context. So the government would analyze the amount of investment using a proportionality test, which means the smaller the total costs need to set up or purchase a business, the higher proportion of these costs must already have been spent. So for example, for a small consulting company, as I just discussed, which would require only $50,000 or $80,000 to set up or purchase, the government will expect the applicant to have already spent 100% of those costs required. By contrast, an applicant could be approved, for example, if they put in 10 million for a business that would require 100 million to set up. So the proportion of the investment required would certainly be different. Now, one thing to mention is that if you are buying a business, not setting up a business, but buying a business to qualify for the E-2 visa, what you would do is compare the cost of buying that business to the fair market value of the business to judge what investment would be considered substantial, right? And another factor you really want to consider with regards to the investment amount is that different consulates around the world have different standards on what amount of investment they consider to be substantial. So for example, some consulates would consider any investment below $100,000 to be insufficient, while other consulates are more flexible in that amount, and they would allow or they would approve E-2 visa applications with investment amounts as low as 50,000, right? So it is very important to work with a law firm such as ours that understands these nuances that differ within different consulates. Okay. Now, we can talk a little bit about then what would be some common strategies to deal with a low investment amount. So the advice here would really be to strengthen the other aspects of the case as possible. And we talk, for example, about the real and operating prong, where the applicant must show that the business is ready to go. So you could certainly strengthen the evidence on the potential for revenue generation and potential for hiring, and also show that there is interest and traction from clients that can support your case that the business is strong in the real and operating and marginality prongs. So some suggestions how you can strengthen these aspects is, for example, getting letters of intent from clients who are willing to work with you to procure your services if you're a service-based company. You could also get a letter from local commerce organizations, such as a chamber of commerce in your region where you intend to operate. You could strengthen your business plan and really emphasize strong profit generation potential. And also a very compelling way you could support this is to already hire a U.S. employee by the time of application. So even if it's a part-time employee or even if it's an administrative job, you can show that your business already has the potential to hire and will hire more workers as time goes on, and that could help offset the relative weaknesses of having a lower investment amount. So yeah, there are some case studies we can sort of talk about to see how that would look like in practice. So the first example, let's say you are opening a business and your investment amount is low. However, you already hired 2 U.S. employees already, and the business has already started taking revenue. And because you already have employees, you can support that the employees are doing the work on the ground, and you already have 10 clients that you're currently serving. So that fact pattern really signals a strong case. And even if the investment amount is low, we can see that this presents a good case for approval for an E-2 visa for the applicant. Now, let's look at another example. So you're applying for an E-2 visa and your investment amount is low. However, you do not want to invest any more money and you don't want to hire anyone until after your E-2 visa is approved and you come to the US. Now, and without further evidence of supporting your business profit generation potential or the real and operating prongs, this could be a little bit of a riskier case, right? Because and the reason why is because there is we have not strengthened the other parts of the application enough to offset the risky low investment amount. So in that case, I would say a weaker case for E-2 approval. All right. So now then, let's talk a little bit about what you would be spending your money on. So when you are investing in your business for the purpose of getting an E-2 visa. So some common E-2 visa expenditures, there is a list here. You can take a look. And really, the way to think about this is what are the legitimate investments that you need to have set up in order to get the business up and running, right? So common expenses include renting a business office space, right? Buying any equipment that is relevant and needed, such as a computer, printer, scanner, office supplies, for example. Those are common. Marketing or advertising fees are good expenses that can really show that you are making the investment to increase your business profile, to increase your business exposure to potential clients that can support your business generation potential. Other relevant expenditures can include licensing fees if you are operating in an industry that requires such a license. Employee payroll, setup costs, and also costs that you pay employees in terms of wages. Those can also be included in your investment. And service fees related to business operations, such as accounting services. And sometimes you can also include legal fees, fees that you pay your lawyers to help with the business setup and the visa. Right. So maybe then this is a good time to talk a little bit about what are some good expenditures versus weak expenditures, right? So not all expenditures are looked at in the same manner to support that it qualifies as an investment under the eyes of an examining officer. So some examples of strong expenditures could include some of what I just mentioned, including marketing expenses, setting up a website, for example, for a business, hosting a website, lease agreement for an office space, that would also be a strong expenditure. Equipment, as I just mentioned, computers, printers, scanners that are reasonably needed for the business. And for a retail business, you can also include the purchase of inventory, which is also a necessary and reasonable part of setting up the business. Furniture. Now that would really depend on how relevant is the furniture and is it really actually being used in the business space. Money paid for IP and trademarks, licensing, wages paid to employees, those are strong expenditures. And as I mentioned before, legal fees used to start up the business and to set up the licensing arrangement, for example, those would also be qualified as strong expenditures. Now, by contrast, weaker expenditures to include, for example, a vehicle, if it is not directly related to business needs, if it is just used for transporting yourself to and from the business location, that would not qualify. That would not be a good expenditure to include as an investment in your business. Travel related expenditures, we also don't recommend including those unless if it's for a very specific conference or if there's a compelling business need, you can prove regarding that travel. And in a similar vein, money spent for client meals, entertainment, in terms of business development expenses are not favored in terms of qualifying those expenses as investment. So in looking at these potential items you could claim as an investment, really the approach is to take a common sense approach. The expenses really need to make sense in light of business needs. And that really would be the question I would encourage you to think about.
Okay, right. So yeah, thank you so much, GA, for that. And I did want to comment that we do see all the questions coming in. So thank you for sending in those questions. And we will, we will reserve time to answer those questions, towards the end of the presentation. So so just picking up, from where GA left off, we're going to talk a little bit about some specific challenges for various types of businesses, starting with a very common one, which is consulting businesses. So I think it's a really, really common question we get that clients come to us and say, I want to start a consulting business, but I have my own expertise and I already own a computer and I have nothing to spend any money on. And ultimately, although theoretically a very low investment, or like a couple $100, $1,000 may be sufficient for you to launch your consulting business. From a business perspective, from the visa perspective, it will not work. There are some investments that are just too low. And, generally what we'd recommend is that you try to spend at least $40,000 and, ideally a little bit more, and then have some amount in a business bank account. This is not a hard and fast number. We certainly have processed many E-2s successfully where they have spent less than 40,000. However, I think the lower you go, the riskier the case gets. And you also have to consider venue, because there are some places that just will not accept, very, very low investment amounts. Applying with USCIS, that's one of the benefits you can get, is they are more open to lower investment amounts. Toronto as well is often open to them, but even there, we're starting to see more and more kind of a preference for, a larger investment amount. In terms of, kind of how to approach this with a consulting business, you want to spend, spend money on things perhaps that you wouldn't have spent yet. Perhaps you don't need to buy extra equipment for the employees you plan to hire. Perhaps you would have waited and hired an employee in year 2 instead of year 1. Perhaps you wouldn't have gotten an office space because they're just really not needed anymore necessarily. However, you would pay for these things, kind of earlier than you normally would have, because it's going to get your investment amount higher. And this is what you need to get the visa. So we always try to encourage people to spend money on things that make sense for their business. So perhaps you wouldn't have done a very large, website or very involved in-depth website yet, or hired a PR firm, or hired, somebody to do marketing for you. But you might do that in advance because it will help your business and it will also help your visa application. I think another challenge for consulting businesses is that there's a concern that the business will just operate with you as a solo consultant and you won't ever hire employees. And so this is something where it is very important that you're able to demonstrate that you have kind of letters of intent, that there's going to be sufficient business, that the company will be able to hire people. And, ideally, if you're able to kind of hire an employee before you file, that really, really strengthens your case. It's not required, but can help mitigate that concern that the officer has that you may just come in and operate as a solo consultant. Another thing to consider for consulting companies is, there's some times where people perhaps they were working for a large company and company tried to sponsor them for an H-1B, they didn't get selected and they don't have work authorization. So now they go get an E-2 visa and their primary client is going to be this one large company. So that structure can work. However, you want to keep in mind that the company has to do more than just work for one large client. Like the officer will kind of see through that structure if they're saying, well, you're just trying to operate as a solo independent contractor for one large company. So, if you're if you're going for a consulting E2 and you, are in a similar type of situation, you just want to keep in mind, you do need to market to multiple clients. You do need to have a business plan that shows that you're going to offer services to more than just one company and that you're going to be able to hire employees as well. So let's move and talk about some E-2 visa challenges for real estate investments. So, real estate, I think, is definitely a very risky area in which to pursue an E-2. That's not to say that they cannot be approved. We have many, many clients that do work in real estate and that are able to get the E-2 visa. However, there's just some important things to keep in mind, and these are just inherently riskier cases. I think when a consular officer sees that it's a real estate E-2, they will kind of look more closely because there's just some, particular concerns. So one concern is that the person has just, basically created an LLC and purchased a property and, maybe they're collecting some rental income or some passive income from that property. Maybe they kind of want to flip a house here or there. So these things do not qualify for the E-2. The company would not be considered real and operating if you just have an LLC that's holding some real estate for you. It's just not, I think it's something that's even on many consulate websites where they say, just to let you know, like purchasing a property in the US is not going to qualify for an E-2. So I think it's a very common misconception, that this is, that's something you can do. In order to have an E-2, you have to show that the company is real and operating, and that it's not just an idle speculative investment that you're only holding for appreciation and value. So you need to show that you're taking in revenue. You need to show you're offering services or a product or a good. You need to show that you will be able to support employees. So some ideas that have worked, one real estate brokerage firm, a real estate management company, if you're doing property management for multiple different properties, a renovation or construction. Some people have done house flipping, but I've only seen that really be successful when it's on a large scale. So let's say, you're flipping, you own, 30 to 40 to 50 properties, or you're doing commercial real estate development on a very large scale. And something to keep in mind when you're doing that type of investment is the investment amount will need to be higher because the actual, things you need to get, if you're going to have 30 or 40 properties, your investment amount's likely going to be well over $1 million. So just, definitely things to keep in mind when you're doing real estate. Something else to keep in mind for real estate is that it's a very regulated industry. And in the US, it's often regulated even kind of within each state. So very, frequently if somebody is trying to do something where they need a real estate license or, some type of, contractor's license, those are things that can kind of be stumbling blocks for these types of cases. It doesn't prevent you from getting the E-2, but you will need to either have the license or to perhaps have contracted with somebody who has the license. Sometimes it's the case that you can't get certain licenses until you're living in the US or until you have a social security number. And if that's not your situation, if you haven't lived here previously or worked here previously in the United States, you may need to perhaps contract with somebody who has that license so your company can start offering the services right away. And then you can provide in your business plan an explanation for how, you plan to get the appropriate license in place over time. So let's talk a little bit about another risky area. So this is, another, I think, very popular area, but a risky area is equity trading companies. So similar, a lot of similar risks to real estate. So, just placing your stock portfolio in an LLC and trading or just trading for family members is really not going to qualify, for the E-2 visa. Again, it's considered kind of passive trading. It's really not going to be considered active enough. If you're going to do this type of business, you really need to show that you have kind of, interest from clients. That you kind of are going beyond just servicing your family and maybe a couple friends. And again, this is another very heavily regulated industry. So if you are going to get into this industry, you need to make sure that you've done your diligence, you understand what licenses you need, you understand what structure the business has to have, and you need to be able to explain that in your business plan in such a way that the reviewing officer, who often will not be familiar with, with this type of industry or the specifics of it, can understand what you're doing and can understand why this meets each of the E-2 requirements, why it's going to be an enterprise that's going to generate revenue, how you're going to offer the service to various clients, the fact, how you'll be able to hire people, the fact that you have the relevant licenses. So another area that I think is, very frequently used, but riskier and something just to keep in mind. So let's switch gears a little bit and talk about some reasons for E-2 denials. I think that, one, obviously we've been talking about a lot is, low investment amount. So, as GA kind of like, spelled out earlier, there is ways to, kind of try to mitigate the risk with low investment amount. However, there are some times when an officer will see that amount and, ultimately will deny the case. There's various things you can do. You can, try to reapply. If you have more money to spend, let's say you had, $60,000 total and you spent 25,000 and put the rest as working capital. So perhaps you spend some additional money, pay for some additional equipment or find other things that are relevant for your business. Another thing you can do is perhaps have a CPA evaluate your business plan and evaluate your investments and write a letter as to the reasonableness of the expenditures. This can be helpful, especially if the CPA is somebody who works in your industry or works with your type of businesses, so they can speak to kind of, what are normal startup expenditures for that type of business. You can also include, kind of market reports, industry reports that support your arguments about what the normal startup costs for this type of business are, to show that you have that what you've spent should be considered substantial. So these are all things that you can do either in the initial application, or if you are denied for this reason, you can always try to reapply using some of these strategies. So another reason, for denial is kind of the nature of the business. As we just discussed, there's certain types of businesses, consulting businesses, real estate businesses, equity trading businesses. These are often flagged as just riskier types of businesses. And, it may be the case that an officer is, not familiar with the business or doesn't think it's a viable enterprise. This is where a business plan is really key to explain how the business meets the requirements. Other things, so a filing location or venue. So you do need to know your venue, and it's good to kind of speak with your attorney to see if they, have, up-to-date information. Consular officers do change posts, do change locations. And right now we're undergoing a time when many new officers are being trained. After COVID, many officers left their posts and now there are many new officers that are coming in. And so we are seeing some, changes in adjudication standards across various consulates as new people are trained and have some of their, subjective thoughts as they adjudicate cases. Another thing, that can potentially be an issue, these second two are kind of related. So if you had a business in your home country that had no employees and that's concerned that your business is going to create jobs, so these are kind of related reasons for denial. And the key here is just, do you meet the marginality requirement? Will the business hire US workers or hire workers in the United States? This is just a very key part of the E-2 visa. It is not meant for a solo consultant, a solo, person to come in to the United States. It's meant to, have the person, support more than just themselves with the business, and they do need to hire people. So let's say that you were a solo consultant in your home country for many, many years, and now you want to come to the US and open a consulting business. In that type of case, even though it's not required to hire employees before you file, it would be much better for your case if you did, because then you're already getting out in front of what that officer is going to be concerned about, which is, well, you were a solo consultant for 20 years. Why should I believe that you're actually going to hire someone, even though your business plan says you will? So if you've already hired someone, you've already paid someone, you get to use that amount that you paid them as, part of your investment, and you're showing that you already meet that marginality requirement. So other things that can happen, issues with the adjudicating officer, consular officers are human beings. They sometimes they're having a bad day. Sometimes they take a particular position about your case and they're not going to be moved. That can happen. So it is possible, if you are denied and you feel like the officer was, either not correct in their interpretation of the regulations, or that there was some other issue going on, it is always possible to reapply. Most consulates will try to give you a different consular officer. It's not guaranteed by any means, but they do try to do that. So that is something to keep in mind. If you feel like it was a really, off-base denial, there are ways to try to argue about, or try to kind of escalate issues with denials that were just legally incorrect. But I think it's very difficult to do successfully because of the discretionary nature of the way that consular processing works. And then the final reason maybe is just, for denial is you didn't meet the requirements at the time of filing. Perhaps if the company is not majority owned by treaty country nationals, or, we had a client come to us once who had spent $2,000 and put $98,000 in a business bank account. This just doesn't meet the requirements. There's just no way that could be considered that someone's spent everything necessary to set up that business with only $2,000 spent. So we advised them on how they could spend additional funds. They reapplied and were ultimately approved. So many of these can be overcome. Really does depend on the reason for the denial, but these are some of the common reasons that we see. So let's talk a little bit about some E-2 visa adjudication trends and some hot topics. So I think, COVID and the E-2 visa. Unfortunately, even, over 3 years later, we are still seeing ongoing impacts on E-2 visa processing. In particular, consulates have kind of come back online in terms of visa processing very differently. Some consulates are, much less staffed than other consulates. Some consulates lost consular officers during the pandemic. There are some consulates that have just started processing E-2 visas again. There are some that are only processing E-2 visas that were submitted in September of 2020. I'd say that, when it comes to, for example, Toronto and London, those consulates are really back, I think, processing E-2 visas in a very reasonable timeline, perhaps a little bit slower than they were previously, but not egregiously so. London used to process cases within about 30 business days. Their current processing times are around 45 business days. So it is a little bit longer. Overall, I think that, things are still slower than they were. And what we hear from consular officers is that is likely to continue, for at least another year or so as they start to get things back on their feet. However, we have seen vast improvements from where things were in 2021. So things are trending in the right direction. When it comes to consulates, timelines are just very, very different between consulates. I believe right now in the U.S. consulate and consulates in Turkey, sometimes it can take over a year to get an appointment. Whereas, the consulate in Toronto, they're reviewing cases within about 10 business days, and then you can get an appointment within about 2 months. So it really is going to, just vary significantly depending on which consulate you're going to. If you're in a situation where you're in the United States and you are either here in E-2 status and you want to extend, or, you're here in a valid status like B status or F status and you want to change your status, that's something you can consider. You can file a petition with USCIS to, change or extend your E-2 status. The benefit of this is you don't have to leave the United States. You can also pay an additional fee and get an answer within 15 calendar days. So there's some kind of, more certainty about timing. I think some downsides are, with USCIS, you're not getting a visa stamp, so you don't get any ability to travel internationally. And you can only get an approval for 2 years, whereas for many people, if they go to a consulate, they might be eligible to get a visa stamp for 5 years. Another thing about USCIS is they are very, very strict on the source and trail of funds for the investment. So whereas many consulates may take a very high level view of the money is coming from personal savings from employment, you provide your tax returns, you show proof of the transfer. USCIS will often want to see an exact audit of the money. So they'd want to see money from your employment entering your bank account, being sustained in your bank account, then being transferred, then being spent on expenditures. So if you have a very complex source or trail of funds, USCIS may not be a good option for you. However, in some circumstances, it may be a good option if you can't get an appointment and your status is expiring soon. All right, so let's talk a little bit about some kind of issues and complex areas that come up with E-2 visas. Some of these we've touched on before, so I won't spend too long on them because we'll get to our questions. So, do you have to hire employees before you file for an E-2 visa? No, this is not required in the regulations. There are some consulates that are nitpicky about this. Anecdotally, the American Institute in Taiwan right now seems to be taking the position that employees need to be hired first. However, this is not correct. It is not anywhere in the regulations. The regulations actually specifically flag the fact that if you're doing a pure startup, you just need to show that the company will be able to hire employees, and make an economic impact over that 5-year period. So no, you don't need to hire employees before you apply. However, it is very strong for the application if you do, and any amount you pay for the employees and any ancillary expenses you have to pay to get the employees set up on insurance or payroll or anything like that, all of that are, all of those are great E-2 expenses. Other complex areas, source and trail of funds. So we just talked about this, with USCIS. If you have a very complex source and trail of funds, USCIS is probably not going to be a good option. They will require that dollar for dollar accounting. Let's say you had money and it transferred between 5 different bank accounts and you can't get them anymore. That is going to be an issue. They do require, a complete source and trail of funds for all of the investment funds. I think GA touched on this earlier, but for loans, loans are acceptable. However, the loan cannot be secured by the assets of the E-2 business. We'll get into this with the questions, but I think someone had asked about seller financing. So seller financing does not work for the E-2, the reason being that in a seller financing situation, the security for that the loan is the asset, is the E-2 visa company. And so that does not work in an E-2 visa context because your personal funds have to be committed and at risk. And if it's the E-2 assets that are at risk, then it's, there's not that requisite element of risk that is required to qualify for the E-2 visa. Gifts are also permitted for the source of funds. The only thing with a gift is that you need a gift letter, but then you also need to know where did the gift giver get the money. So it's not, you can't kind of eliminate that requirement to show documents based on asking, getting a gift. You still need to know, where did the gift giver get the money and then provide all of those documents. Something that comes up quite a bit, E-2 visas for 2 investors. This is fine, this can work, but the ownership does need to be 50-50. So if the ownership is different, let's say it's 2 Canadian partners and the ownership is going to be, 70-30. In that case, it would need to be 1 investor and 1 employee. If you want to do 2 investors, it needs to be 50-50. So substantive changes to the E-2 business after filing. I think sometimes people, they get their E-2 visa and then they think it's good for 5 years and whatever happens, happens and it's still valid. And that's not the case. So let's say that your business is acquired or there's changes in kind of the ownership and now you and treaty country nationals don't own a majority of the business anymore. At that point, the business is no longer eligible for the E-2 status. You do need to kind of continue to meet the requirement of the ownership in order to continue to use your E-2 visa. Similarly, the changes in your type of business. So let's say that you had a wedding photography business and you decide that you want to run a restaurant. So these are vastly different lines of business, and you cannot just start running a restaurant without first getting approval from USCIS. So, you can you can go to USCIS or to the consulate and say, I have this new business idea, I'm making a new investment, but you may need to just submit a brand new E-2 application at that point. Let's say that you had contemplated in your business plan that you would do, two different things. If that was already contemplated and that was already approved, then you can go ahead with that. But what you can't do is just start a whole new line of business without first getting an approval. The final thing we'll talk about with kind of some complex areas that come up are kind of family business purchases. So I think a very common scenario where someone wants to come to the US and perhaps buy 50% of a business owned by a family member. This can work, but it's going to be scrutinized much more heavily. And so what you want to do is get some type of objective third-party valuation that shows, that whatever amount you're purchasing the business for is the actual fair market value of the business. So for example, if the business, has assets and revenue and cash flow and, millions and millions of dollars, and you're paying your relative is selling you 50% for $30,000, that's not going to work. You do need to have that evidence that what you're paying is fair market value, so you can show you've made a substantial investment. So let us turn now to questions. I think we have many questions that have come in, and we will, get to the ones that we can. GA, there's a question here that someone's asking if the business can be a work from home business, a remote business. So what do you think?
Right. So there is no hard requirement regulatorily that the business has an office, but we highly recommend that the business does not operate from home and actually have an office. And the reason why, well, there are many reasons for this, but it supports the real and operating requirement, and also it supports, it can support your investment amount. Getting a lease is a very popular way for many of our clients to boost your investment amount. So yes, having an office is highly recommended, although it is not 100% required by the law.
Perfect. So then the second question is on, the seller financing. So I kind of spoke to that,
Right.
which is no, seller financing cannot be, it cannot be used for the E-2 investment.
Right.
So now someone's asking about what consulate in Mexico has the most E-2 visa demand. I've heard different officers from different consulates are more strict or require a higher investment amount. So the two consulates that have been identified here, those are the two that process E-2 visas in Mexico. I think that I couldn't speak to exactly, what the situation on the ground is with consular officers in each of those offices. Other than that, both of them do process E-2 visas, and so either one is a viable option, in applying for the E-2 visa.
I own a property in the US. Would this have a negative impact on my E-2 application? And now I think this is getting to non-immigrant intent. And my opinion is that, just the fact that you own property does not necessarily needs to have an impact on your E-2 application. And there is really they don't ask for you to disclose all of the properties that you own. So I don't see how this could really come in. And with regards to non-immigrant intent, usually the E-2 visa, having a signed declaration to that effect is sufficient. So I don't think this would present as a particularly risky fact pattern.
No, fully agree. So there's a question here on kind of exemptions for tax purposes. So for those types of questions, you would need to speak to a cross-border accountant.
Right. How much investment is enough in a case where the existing business sale is bundled with property sale? So yeah, so I mean, if what you're kind of meaning here is that you're purchasing a business and the business is on some land and the land is part of the purchase, that is fine. However you wanted to structure the sale is fine. If you wanted to break it out so that there was business assets and property assets and they were different, you could do that. I think there wouldn't necessarily be a requirement to include the land. However, if it bolstered the investment amount, then that may be a good thing to do.
But that would be, that's fine to do that. It's possible to do that, and that's fine.
How long would it take to set up a business and apply for the E-2 business in normal conditions? So yes, that would definitely depend on the vehicles you are using. We do offer business setup services as well, so we can certainly help you and provide guidance with that. For the application and preparing for the application, once the applicant would need some time to set up the business and make the necessary expenditures, sign a lease or things like that. Or if you're hiring an employee, you would hire an employee, so you would sort of build in those kind of preparatory steps. And once that is done, we do prepare the E-2 application once we have all the documentation within 15 business days. And so once we submit the application, then the processing time will depend on the consulate. So we will be able to give you more guidance on that as well.
Perfect. So someone's asked if money's invested and you're not approved, what recourse do you have? So this is, I'd say, one of the most difficult parts of the E-2 visa, particularly for a startup, because the money does have to be invested and at risk. So, there's certain things you can do to try to mitigate some of that risk. For example, if you prepay a certain amount of lease, you can try to write a provision into the lease agreement that indicates that, the money will be kind of refunded if you aren't able to ultimately use it. Obviously things like equipment, some of that, keep the receipts and you can send it back. If somebody is purchasing a business, then there is an option to do what's called an escrow arrangement, where basically rather than transferring the money to the seller, you transfer the money to an escrow agent, and the only condition for the release of the funds can be the approval of the E-2 visa. But if the E-2 visa is denied, then the money would go back and would not go to the seller. So that's kind of one way to protect yourself, particularly if you're purchasing a business, there is an ability to, very clearly protect yourself, much more so than with a startup.
Right. Can a business start getting revenue before the visa is approved? And the answer to that is yes, but with a caveat, right? So you yourself cannot start working for your E-2 company before your visa is approved, right? So you do need to have employees who are doing the work on the ground in order for this to work. But the answer is yes, the business can start generating revenue.
One other thing I just want to say about that is that let's say that you're not in the United States. If you're in the United States, then as Jay said, you cannot work for the business. Let's say that you're in Canada, and you've started up your business and there's someone that wants you to perform on a contract. That's fine. You certainly can do that as long as you're not physically in the United States. Something to consider, though, is just that, sometimes taking in a lot of money while you're also making your investments can kind of muddy the waters in terms of the documents that you're providing. I think it's okay. Like it's certainly something that can be dealt with, and it's, not necessarily an issue, but especially if you're in the United States, you aren't able to work for the company yet. So you want to be really sensitive to that, and make sure you have employees if you are actually in the United States.
Right. Great points. Employees. Can it be 2 employees for 24 hours a week, 3 days full time? This is a catering company and events are basically on weekends from Friday to Saturday, Sunday. This can work. So for hiring employees, there is no requirement that the employees are regular full-time W-2 employees, although it is preferable to have such employees. You can certainly prove marginality by hiring contractors or part-time, but really it must be, reasonable in light of the business type. So yes, so yes, the answer is yes, and it'll depend on the type of the business itself.
Yeah, another thing I'd say just is that, when it comes to the time for renewal, there's nothing in the regulations that requires this, but we generally do recommend you have at least 3 to 4 full-time employees by that time. If you have hired many people over the years, or if your business is the type that subcontracts and perhaps you paid hundreds of thousands of dollars to independent contractors, all of those things can be used, to try to bolster the case and show that the company's not marginal. But ultimately, if you're applying and you only have, 1 or 2 part-time employees, after 5 years, I think that's going to be an uphill battle for renewal. So some of it is kind of what is your risk tolerance, in terms of when you reapply. And generally you will want to showing that you're going to have those 2 employees maybe for the first couple of years of operations would likely be fine. But then, as you get on, they would expect to see, more employees, I think, than just 2, part-time employees.
Right, definitely. And Kelly, do you want to take the next one? Do I need to get a license to run the business before the E-2 visa?
Sure. So not necessarily. So, in terms of whether the business will be considered real and operating, you need to have a plan that makes sense to the officer. So if what you're saying is the license is, completely, ready to go, all that's needed is for me to get my visa, like get my social security number, and then the license will be approved in 2 weeks. I think, yeah, like that type of situation, likely it can be fine. However, for, this is mentioned like a liquor license or childcare. Sometimes to get a license to run some type of childcare business, it might be much more involved, might be months and months. That type of situation, you would need to have the license, I think, lined up ahead of time, or at least some reasonable plan to have the license within a couple weeks of entering the United States. If we're starting to talk about several months where you wouldn't actually be able to run the business because you're applying for the licenses, I think that's going to be an issue, for real and operating.
For the Toronto consulate, is a 50K USD investment for an engineering firm good enough? And if we still have no revenue yet, but one USA employee hired, will this make an okay case to apply an E-2 at Toronto? Yeah, so we have had approvals with 50,000 investment range. I do think, though, this is a very fact specific question. So definitely reach out to us for a consultation, and we will look at all of the facts holistically.
Yeah, and I will say, I think, 50,000, I think, is on the significantly lower side. So
Right.
definitely would be kind of a risky case. If you weren't able to get some additional funds, like, even to be working capital that didn't have to be spent. Um,
Right.
so I'll take the next one just because I think I
Yeah.
had just mentioned this, which is, if you get a gift, do you still have to provide documents for the source of funds? And the answer is yes, you do. So if you're getting the gift is going to you as the investor, they're going to want to see, where did your brother earn that money?
Right.
So another one is every business category suitable. So the E-2 visa is for for-profit businesses. For-profit businesses that have sufficient revenue to prove they're not marginal, to sustain more than just the investor and their family. So as long as the business type is one that does that, and is, legal, that's certainly, I think, many different types of businesses can qualify. Not every business type will work. There's some legitimate businesses, that are, not considered legal in the United States, for example, in the cannabis industry. We're seeing this a lot, with kind of companies in Canada where they're, operating under the law, but, in the United States that wouldn't work. So not every single business category, but many, yes.
Buying 50% of a corporation for a gas station business. So you can certainly, do apply for an E-2 visa through a business purchase, majority shares of a business. With this, though, I would definitely encourage you to set up a consultation with us to really look at your approval chances. Do you want to take the next one, Kelly, about
Sure.
consulates?
I mean, so I think that, so one thing I'll say is that also I think this is kind of always changing, because you're kind of having consular officers move between consulates. In terms of consulates, that I wouldn't say that this consulate always requires higher amounts, but so for example, in Japan, that's a consulate where they're doing a lot more with kind of multinational companies that are making kind of very large investments. So I think that they are not as frequently seeing very kind of smaller investors. I think, across Europe, they're a bit more familiar with kind of the individual small startup investor who's maybe investing around 100,000. For a while, Argentina was very unfriendly for smaller investment amounts. We have had some approvals there with investment amounts around 100,000, but those were cases where there was very significant, kind of strong aspects to other parts of the case. So I'd say it is always changing, but there's, important to kind of just speak with your attorney and understand where are things in the current place. I think Toronto is generally friendlier to lower investment amounts. I think, London, I think, is another reasonable consulate. I think they often like to see, closer to 100,000, but if you have a reasonable business plan, I think, very possible to get approved with less.
Right. So consulting E-2 visa, there are some questions about expenses, office space. Does co-working space work? Yes, it works. And for terms, that would really depend on your business needs. We frequently see, both long-term and short-term leases, how to hire workers before applying for an E-2 business visa from abroad. Does one need to show hiring workers before applying, or can you show in a business plan? So know that there is no 100% requirement to have workers before applying, although that can certainly be a strengthening factor, especially if your business, if your investment amount is low. Website, showing money spent on website. Yes, that counts as marketing costs for your business, and what are the planned expenses required for the E-2 visa. So for the E-2 visa, we really want to show that you've already spent the business. So if there are planned expenses, we don't add that in your investment amount usually.
Right. So I'm going to answer just a few of these very quickly because we are coming, to the end of our time. So, right. When they reject an application, do they explain their reasons? Sometimes they do, sometimes they don't. Sometimes you get a generic 214B form. Sometimes you get a more specific form. So unfortunately, they're not terribly consistent in terms of waiting to reapply. I'd say set up a consultation. That's a very kind of fact specific question as to whether or not, as to when to reapply and how to do that. In terms of getting work authorization for a spouse, you no longer have to wait to apply. You basically can just enter with the E-2 visa. Your I-94 should say E-2S. As long as it says that, you can work right away. Can two brothers apply with the same business? Potentially, yes. 50-50 ownership, both need to make an investment. I would say set up a consultation to discuss that one. In terms of the source of funds, coming from a personal account, how many months of bank statements does it need to be shown? It would just depend on how much you were trying to demonstrate that you had invested. So, and you would need to show more than just bank statements. You need to show actually where the money was coming from. In terms of, setting up an LLC, should you pay before contacting us? I always recommend people contact us before they spend any money. This is so that we can vet the source of funds, make sure it's appropriate, and then kind of help you have the, follow the trail of funds. Can you have a virtual office? Yes, it's possible, but it's not as strong as having an actual office space. Can you run an Airbnb using this visa? Airbnb, very risky, like along the lines of kind of real estate going to be viewed maybe as passive unless you're doing it on a very large scale, and have some other type of service that you're offering. Let's see, does the office lease spending need to be a certain amount? It does not. All right, so GA, I'll have you if you want to start doing some of these last ones, and then these are I think we have 8, and that's the last that we will take because we need to wrap up our webinar presentation.
Yeah, sure thing. Maybe let's spend several more minutes on this. So the ownership is 70-30. Can one treaty investor and one treaty employee both work in the US? Yes, so they both need different E-2 visas. And so one application we would do for the investor and another E-2 application for the employee. Yes, that can work. How can you make investment in the business without being in the US first? So there are 2 ways you can do it. You can get into US with a B1 visa, for example, business visitor, and you can make those business connections and networking while you're here. That is certainly fine, and you can buy things while you're here, or you could, you could direct the process remotely. So there are different ways you can do this. You're changing status from F1 to E2 via USCIS. So if you change status, then it just means your status is changed for that particular stay. As soon as you leave the United States after you did the change of status, you would need a visa to come back in to the US as a treaty investor. So you would need a visa once you leave.
Yeah, and I think one key point is that you're not finalized. It's not the same as like with an H or an L where you've gotten approval from USCIS and then you go to the consulate, right, and you have more of a rubber stamp. They're going to view the case as a brand new case, and they don't have to approve it just because USCIS approved it. They will view it, in their own right as a brand new case.
Pending I-140 may have an adverse impact on E-2. Yeah, so that could be a little risky. There are different ways to deal with that, but I would definitely set up a consultation to discuss that. Better to acquire an existing business or a franchise. Well, that really depends on your business needs. We have seen, approvals for both categories, so it doesn't matter that much. Can I enter the USA with a B1, B2 visa to get the license or permits? Yes, that is certainly something you can do. to develop the business before applying. Legal fees, we will certainly be able to give you that information. Once you set up a consultation, we will send you a retainer that'll have all the information. Okay, I think we have went through all of the questions.
All right, perfect. Well, thank you, everyone. Thank you so much, GA, for sharing your knowledge.
Thank you,
I
Kelly.
hope this was helpful. I think it was, certainly very interesting. Thank you for all your great questions, and I hope everyone has a wonderful afternoon.